Smith, file number 255399. Record should reflect Mr. Smith is present here in the courtroom. Can you hear me, sir?
Not very good.
Okay. Are those helping?
I will tell you, Your Honor, when I tried them on, I didn't really find them to be of any help.
Go ahead and speak.
I'll try to speak up loud. Can you hear
Okay,
me?
I can hear that.
Okay. All right. Can counsel put your appearances on?
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Roy Smith. Your Honor, if I could approach, I have a signed pretrial plea agreement. It would indicate that Mr. Smith would plead to one count of misdemeanor assault, or domestic violence, excuse me. It's a 93-day misdemeanor. The prosecutor has no objection to deferral status. That would be our request.
Ms. Koch?
That is a correct statement of the offer. We have talked to the victim and he is okay with the deferral.
All right. Is the victim, do they qualify as a domestic, or is this, am I taking a factual basis to the charge?
It's a son, so they are former residents of the same household. They were not on the date in question, but former resident qualifies.
All right, Mr. Smith, have you been able to talk to your lawyer about this plea agreement?
Yes,
And you understand that you're going to plead guilty to one count of domestic violence? That's a misdemeanor that has a maximum possible penalty of up to 93 days. Do you understand that?
yes,
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. With that maximum penalty in mind to that charge of domestic violence, what is your plea today?
Guilty.
Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you and to appear at court and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights. You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we said here in court today?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are guilty?
yes,
This incident happened on February 20th of 2025, is that correct?
yes.
Okay. Where did this incident take place?
At my home, it was in my garage.
Is your home here within Crawford County?
Yes,
Okay. And was this an incident with Brandon Smith?
yes,
And that's your son?
yes,
And you used to reside together at one point, is that
Yeah.
correct? Okay, tell me what happened.
well, he was drinking and high on drugs, and he come over to my house, and we just got into hassle, and when we did, he come at me and I picked up the shovel and hit him with it.
Okay. All right. Ms. Koch, any further questions?
No, Your Honor.
Mr. Thompson?
No further questions. Thank you.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No,
Mr. Thompson?
Nothing.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
yes, Your Honor.
Thompson?
Yes, Your Honor.
Mr. Smith, I find that your plea is knowing, voluntary, and accurate. Based on your testimony, I find there's a factual basis to support a finding that you are guilty of domestic violence. The court will accept your guilty plea. We will set this for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney prior to that date. And today you're going to meet with Mr. Haven from the probation department for a pre-sentence report, okay?
That was one of my questions, Your Honor. I didn't know if the court wanted a full PSI, an abbreviated PSI, or no PSI. Given that it's a misdemeanor plea, I would just ask the court for direction.
Yeah, I think Mr. Haven usually do like a shortened misdemeanor PSI.
This is gonna be on a delay as well, correct?
Yeah, the deferral.
Yeah, the prosecutor has no objection to deferral.
So yeah, I mean, if we're doing delay update 11 months down the road, then it'd be good to have the PSI, so we can do a misdemeanor PSI.
Okay, great, thank you. Thank you, that's all for today.
Thank you, Your Honor. Just return these. I'm not sure. I didn't.
Mr. Trush, is Ms. Creed present?
Yes, Your Honor.
Okay. People versus Tanya Creed, file number 255408. The record should reflect the defendant present here in the courtroom today. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Ms. Creed.
Thank you. This is set for a status conference today. Mr. Trush, can you tell me where this file is at, please?
Your Honor, we're going to be asking for a brief adjournment on this. Ms. Creed and I lost contact during the last period, and I was able to get an updated number for her today. I actually think it's the same number. She just indicated her phone had been shut off for some period of time. Unfortunately, because of that, we didn't really have an opportunity to discuss the different options she has for today's hearing. While I have a suspicion of where this case is headed, I think they are discussions that need to be had.
Ms. Koch, any objection to the adjournment?
Your Honor, I would ask that this is the last adjournment in this case. The offer was made the first week of March. At the last hearing, it was indicated that this case was headed to trial. This is a victim case, and with those cases, the sooner we get them to trial, the better. Thank you.
Great. So we'll set this matter for a hearing in about 30 days. Between now and then, Ms. Creed, you just need to make sure that you discuss with Mr. Trush any plea offers and that you be ready with a final decision at that time, okay?
Okay.
Mr. Trush, anything further today?
No, Your Honor. Thank you.
Ms. Koch?
No, thank you.
Make sure that you stay in touch with Mr. Trush, and again, we'll send you notice of the date and time of that hearing in about 30 days, okay?
Okay.
Thank you.
All right. Thank you.
Is this Mr. Kibbe?
Mr. Kidd.
Kibbe, if you'll come up to the podium, please. Go on the record in People versus Elijah Kibbe, file number 255416. The record should reflect Mr. Kibbe's present here in the courtroom. Counsel for the appearance on this file.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Kidney. Your Honor, we're going to be having this matter docketed for a trial. We do plan to file some motions. A transcript of the prelim has been requested, although it hasn't been completed yet. So I would ask that the trial date be at least 60 days down the road. That should give us ample time to get that transcript, file whatever motions need to be done, and have them heard prior to the trial dates.
Ms. Koch, do you have any objection to that time frame?
No.
And Ms. Koch, how many days trial?
No, I think we can do this in one day.
I would tend to agree.
So we'll set it for a one-day jury trial at 60 to 90 days. I will set this for a final status conference on the motion day immediately prior to the trial date. That'll be the plea cutoff and the motion cutoff. And I'll set it for a one-day jury trial. Ms. Koch, any other dates that you address for your side?
No. Thank you.
Mr. Trush, I'm just for my own information, what are the nature of the motions that you're anticipating?
So I anticipate it'll be a suppression motion, challenging the validity of the search.
Okay. Thank you. So Ms. Koch, once that's filed, if we can have counsel kind of communicate, or if we can request when you do get a hearing date for that, enough time, we have to take some evidence that's, it's set with more than just the 15-minute.
Understood, and my anticipation is that we probably won't need additional evidence because we developed that issue at the prelim, which is why we're waiting for that transcript.
Okay. Spoke anything further from your side on this file?
No.
You have, what's your next matter, Mr. Church, that you have the client ready?
I have everybody ready, and I think we have Mr. Duvall, Ms. Hellebuck, and Ms. Harriman all on the 145, so.
Ms. Hellebuck can come forward, please. We'll call People versus Heidi Hellebuck, file number 255402. The record should reflect the defendants present here in the courtroom today.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Church on behalf of Ms. Hellebuck.
How did we want to proceed today, Mr. Church?
So, Your Honor, we are still waiting for a couple videos from the prosecutor's office. I followed up with Ms. Hilliker today. She's indicated that they requested them and she followed up on it today, but they don't have them yet. What I would suggest to the court, given the posture of this case, I think we likely could get it in the queue for a trial with a final status conference before it. That should give us time to get the videos, review them, and then again, if we do have a resolution, we'd be able to get that entered in.
Okay, Ms. Koch, 60 to 90-day timeframe.
That is fine. The offer in this case was a misdemeanor. I understand they're rejecting that offer. Frankly, I think the videos that we've already provided show everything, but I guess if we have requested them so we could see them, the exact same things from different angles. We are prepared for trial.
Is that timeframe sufficient for you?
Yes.
And Ms. Koch, 1 day?
Yes.
I think that would be sufficient.
So we'll set it for a 1-day jury trial, 60 days, 60 to 90 days out. The court will have a final status conference. That'll be the motion and plea cutoff. Ms. Koch, any other days I can address for your side today?
No.
No.
Salva, did you have any questions about how we're going to proceed with your case?
No.
Thank you. Just make sure that you stay in touch with your attorney, okay?
Thank you.
Thank you. Versus Duvall, case number 255409. The record should reflect Mr. Duvall's presence here in the courtroom. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Church on behalf of Mr. Duvall.
How did we want to proceed in this case today, Mr. Church?
Your Honor, I'm going to be asking for a 30-day adjournment on this matter. We've consulted with an expert. I expect to have the report from the expert in any day now. We actually were cautiously optimistic that we would get it before the end of last week. Didn't quite come in yet, so I expect we should get it any day now. Once I get that and can provide it to the prosecutor, I am hopeful that we're going to have a resolution at the next hearing date.
I would not object to the adjournment. I have spoken to defense counsel on this case numerous times as well as the victim. If we don't have a resolution at the next hearing, the offer will be withdrawn and we will be going forward towards trial.
Okay, we'll adjourn today's hearing. We'll reset this for a status conference in about 30 days. Mr. Duvall, it's important that you stay in touch with your attorney to make sure that you're prepared to go forward at the next hearing. Okay?
Yes, sir.
Anything further, Mr. Church?
No, Your Honor, thank you.
Oh,
No, thank you.
Yes.
People versus Harriman, file number 255417. The record should reflect Ms. Harriman's present here in the courtroom today. Thank you, counsel, for your appearances on this case.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Church on behalf of Ms. Harriman.
How do you want to proceed today, Mr. Church?
Your Honor, we are in receipt of an offer from the prosecutor. ultimately, I think it's an offer that we likely will take. However, I just became aware, we were aware that there's a second matter in Otsego County right now. We're set to have our first status conference in circuit court on that, I think in maybe 2 or 3 weeks, on the July motion week. I've just been informed, though, that there's another set of charges that may be coming down, or not maybe, will be coming down in Otsego. So I'd ask for a little bit of time so we can resolve it globally. I don't want her to potentially sit jail time and then have a whole new set of charges come down after it.
Ms. Coe?
Your Honor, the offer was made last month. It's a relatively new file. We have gotten the drug test. It took a while. Something happened with pretrial services. She did have a positive test on 5/1, but 2 negative ones sent, so they're not at this time revoking her off or her bond, but plan to if there's another positive test. We would agree to 1 adjournment.
Okay. It makes sense to me if there are other charges coming and you have additional files in Otsego County to try to resolve everything together. So the court will set this over until July.
If I could ask for 60 days, just because even if we get the charges up right away, we still have to get them up to circuit court.
We'll set it over till August. For stats conference. Opening further.
No, thank you.
Mr. Church.
Nothing further today, Your Honor.
Ms. Harriman, do you have any questions at all? So it's important that you stay in touch with Mr. Trush. Otsego County and the file is already there. Okay, good. So it's really important that you stay in touch with him on all matters so that we get this resolved. It's also important that you comply with your bond conditions and not be using, because if you are, your bond's going to get revoked and you're going to sit in jail. Okay. So that's all for today. Thank you. Our next matter is People versus Letson at 2:00. Those parties ready yet, and we're a little bit ahead of schedule, so we'll take a recess and come back on the record at 2:00. Okay, we're on the record in People versus Douglas, case number 2553993. The record should reflect the defendants present here in the courtroom today. If I could have counsel to your cases on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Natalie Bublitz.
This is the date time set for sentencing in this matter. Have you had a chance to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes, I have, Your Honor.
Mr. Thompson, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Coke, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocation?
Yeah, this case is hard. I've been dealing with Ms. Bublitz for years now. She appears to be a very nice person. She gets her substance abuse under control, and then she falls right back down the rabbit hole repeatedly. I mean, she's 26 and she already has 7 misdemeanors and 1 felony before all of these before these cases. I just don't know what the answer is. I mean, at some point, and she's getting very, very close to it. I was actually surprised this wasn't a recommendation for prison. Community sanctions aren't going to work anymore. We've tried probation. We've tried just about every type of intervention for her, and she's just not getting the hint. So I don't know what the court wants to do. I mean, we're in guidelines now that give her an opportunity for prison. She certainly, if she were to get out and continue down this path, prison would be the absolute only thing we could do. So I'm not sure. I mean, she'll probably say, it's important to have a child, but you're putting methamphetamine in a child's onesie to try to hide evidence. If you don't realize you have a problem, that should probably be a big red flag. So I'd ask the court to follow the recommendation, although I do think this is a case that could very easily be a prison case. Thank you.
Thank you, Mr. Thompson.
Thank you, Your Honor. Yes, I've been working with Natalie for some years, and she really is, when she's not using, she's the sweetest person you ever met. She's a very devoted mother, and she's had trouble with relapsing with substances, and it's sad to see. It's sad for society. She's got 2 kids who she loves very much. She's now in an NA case. The court's familiar with that. She's working the case. She is getting services. I believe the court received our letter from Wellspring. Okay, thank you. I had another copy in case that didn't go through, but she is working that case and working that system because she needs. I don't know that Natalie would get clean for herself. I think she might get clean for her kids. I think she knows now that she has to, and that losing her kids is on the table. And honestly, that's always been the most important thing. I think that's at risk now is really going to motivate her. This is a sad case. I want to make sure the court understands this methamphetamine was in a container. It's methamphetamine. It's not fentanyl. It was placed in the child's onesie. She's taking responsibility for that. I think it drives home the point of how she didn't have that mental separation. She didn't have that sort of awareness in society that we would that was a line she shouldn't have crossed. Because I think she needs to mentally get herself out of that world that she keeps getting pulled back into. I want to assure the court that she is very motivated. She's very motivated to keep her kids. She's very motivated to keep parental rights. I talked to her about boot camp and the fact that she could probably get a shorter sentence if she got a prison sanction. If it was less than 36 months, she would probably qualify for boot camp. It's never a guarantee, but she seems like she could. She wanted the court to know that she wants to stay in the community if she can. She wants to continue working her NA case and her services. She wants to do what she can with this court to preserve her parental rights. With this court, I mean by the companion case, the NA case. But she wants to do what she can in this case and in that case to preserve her parental rights. She really is getting down to last shots in terms of parental rights, in terms of her kids who need her. And she knows that, and she feels terrible about this. So, Your Honor, we are asking the court to follow the recommendation. And I really hope that this does end up with a happy ending, with the reunification, and with Natalie being clean for her children. Thank you.
Thank you, Ms. Woodward. Anything you wanted to say today?
And I put my daughter in danger this time. And there's no, like, I made the biggest mistake in the whole world. I didn't hurt my daughter and my son's life and my life and my family. All I can do is go forward and make better decisions for them. To make myself a better person so they're safe. I take full responsibility for my actions. That's it.
Oh, do you have a sheet?
Yeah, Natalie, if you need to take a minute, it's okay. I mean, the judge wants to hear what you have to say, so it's okay. If you need to take a couple deep breaths, all right?
So I did read through the report. I'm familiar with what happened in this circumstance, and there's a lot of information in that report about your circumstances generally and your background. Take all of that into consideration, and also what you had to say here today, what the lawyers have had to say. And there's a couple things that stand out to me. Number one, you seem to be really genuinely remorseful for the danger that you created in this case. And it's concerning, and to me, it is a really good illustration of the power of substances and what they do to people and what people will do to be able to continue using, and the amount of danger that they'll put themselves and even other people in, including the people that they love the most. That's how powerful that is. And this case is a frightening reminder, illustration of that. Because I don't think, from everything I've seen from you and read about you, that absent that you would put anybody in danger, let alone your own child. It's clear that that's making you do things that you wouldn't otherwise do, and that aren't generally made up to do. And so, to me, that's a mitigating factor, because I think if you can get a hold of this, you do have the potential of moving on, and then you're still very young, 26. The concerning thing to me, of course, is the pattern and your inability so far to be able to get your arms around it, and the fact that you have gotten to the point where you've been putting other people in danger because of it. And so I don't see a lot of value in just repeating what we've already done here in terms of probation and local jail time. I think having, from what I read in the report, you would be eligible for the boot camp program. I think trying something different is the option that is the best in this case for you. I think it's going to give you an opportunity, number one, to get out probably earlier than you would if you were a jail sentence. You're going to go through some programming in the boot camp program that you're not going to get here locally, and may have an effect over and above just sitting in the jail cell here. And I think, again, in my view, and for you and for the community, trying something different has a better chance of success than doing what we've already done in the past. It would be within the guidelines, and I think it's reasonable, justified by the circumstances. So the court is going to sentence you as to count one, to the Michigan Department of Corrections for a period of 18 months. Years. You have credit for 114 days served. Where it's going to order. It's a assessment of $130, court costs of $325, attorney fees of $350, $186 state costs. Three, also 18 months, 4 years, with the Department of Corrections, and 114 days served. No additional fines and costs, and then count two. 1 year in the Michigan Department of Corrections with credit of 114 days, and no additional fines and costs. All those sentences to be served concurrent to each other. Court do not have an objection to your participation in the boot camp program. Once the court receives notification, I will sign an approval of that.
And Your Honor, I'm not as familiar with this. When I look at basic information report, page 1, there's a line that says SA. I don't know if that was because of the wreck. But I just wanted to make sure this came through to MDOC in a way that's correct. I'm looking at this sheet, Your Honor.
Yeah, what I read is that based on
Yeah. So I didn't know if I needed to ask if this page be changed.
I don't have any
Or if that's
objection.
filled out that way because of the
Is that the
original
101?
wreck. This is the one I'm looking at. Then you get down to SIA eligible or so. Because I know we were talking about this as late as last week, given the,
Okay. Yeah, we can take a look at that,
Okay.
correct that.
I just want to make sure that it's MDOC with the correct format, because my understanding is she's eligible, the text says she's eligible.
So I'll have that changed to yes, if Department of Corrections decides differently, then they can change that.
All right, thank you.
I don't want some. Cars, but, did you have the ability to appeal the sentence, Mr. Woods and Mr. Thompson's gonna? Some papers there that explain what your thought rates are.
So these are yours. You're gonna walk out of here with these 2 pages. If you were gonna file an appeal, the time limit is on there, 14 days. And you would send out these sheets. These will both start the appeal and request a court-appointed attorney. So those are your copies, okay?
Ms. Coach, anything further on this file?
No, thank you.
School list of Mr. Letson here. I'm gonna call that case, that's set for 2 o'clock versus Letson, file number 55389. So you could put your parents on.
Sierra Coke on behalf of the people.
This was set for hearing at 2 o'clock, it's now 2:30. I don't see Mr. Velo or Mr. Letson present. Ms. Cook, you had any contact with counsel on that?
I have, and they've attended the prior hearings. We talked about doing a plea offer. We've emailed. I'm kind of surprised they're not here. I certainly can send them an email. Usually they appear via Zoom.
Right, and I don't see them in the Zoom waiting room. I think the court's just gonna notice this for another plea hearing on the next motion day. I don't find that there's been any prior issues with your insider counsel or defendant. So we'll renotice it for hearing on the next motion day and we'll proceed at that time.
Thank you.
Mr. Laws, your attorney's still next door.
I do believe so, yes, I haven't seen him today.
We'll take a short recess when Mr. Vernon's available. We'll proceed with that. Mr. Vernon, were you ready on Mr. Law's case?
Yes.
So on the record in People versus David Law, file number 255382, the record should reflect Mr. Law's presence. But you have counsel for your appearances on it.
Sierra Coke on behalf of the people.
And we're on behalf of Mr. Law, who's present, standing to my right.
Mr. Vernon, how did we proceed in the trial today?
So we're going to be asking the court to adjourn this out. I had a couple of conversations with Mr. Law, I had a conversation with Ms. Coe. We are, I think, close to a plea agreement on this, which is like, I think 2 weeks is what Ms. Coke and I agreed to, if the court could put that on the next date, so we could finalize that plea agreement.
Ms. Coker.
I had told the court twice that I was going to revoke this plea, but unfortunately, I understand the circumstances have changed with Mr. Vernon getting the new cases here and Mr. Vermouthi being off of it. And I don't want to fault defendant or his new counsel. So I will allow the offer to be remain open until the next hearing. And we'd ask for the next available date.
Okay, so we'll set this for the court's full motion day in July. And so, Mr. Law, it's just important that you stay in touch with your attorney between now and then, okay?
Yes, sir.
Mr. Vernon.
I just wanted to apologize for being late. I was stuck in front of the court and I couldn't get out. So I know I was in the building. I was just apologize for being late.
No, thank you for saying that. And I think Sarah let us know on the record. So, thank you.
Thank you.
Thank you.
Okay. Are you ready on Mr. Khan's case?
Yes, Your Honor.
People versus Michael Khan, file number 255401. Executive counsel.
Sierra Coke on behalf of the people.
And we're on behalf of Michael Conn, who's present, standing to my right, Your Honor. There is a plea offer in this matter. I've been working with my client to try and find sobriety court to get him into. The charges are operating while intoxicated, third offense. He is a resident of Oscoda County, and we've been working with them trying to get him into that county. There's a hiccup with regard to his criminal history. They won't allow a violent offense into the program. He has a domestic violence as a prior. I can't tell whether I was unable to, at least up until right now, unable to figure out whether that has been deferred or not. And I don't know whether that deferral would make him eligible if he was granted a deferral in that case. So I would ask the court for, again, I'm asking for 2 weeks in this just to see if I can't touch base with Oscoda to see if he's eligible pursuant to that domestic violence and whether that's a deferral or not.
Okay, Ms. Koch.
I think this is our first circuit court conference on this case, so I would not object to one adjournment. The plea offer will be withdrawn at the next hearing.
Mr. Vernon, we'll set this to the, I'd be willing to go out as far as the mid-July.
That's fine.
Is that,
Yeah,
just don't want to overload that.
no, I've just been asking for a lot of adjournments today. And I feel guilty about it.
Okay, so we'll set this for the mid-July motion day for a status conference plea hearing. So Mr. Khan, between now and then, just make sure that you stay in touch with Mr. Vernon so that you're ready to make a decision on any plea agreements at the next hearing. Okay.
Thank you. We'll be in touch. Yeah, thanks. Thank you, Sierra.
Yes.
Lovely night going on.
No, that got adjourned.
Okay,
I'm not sure why I can't remember that.
probably underlying criminal charges.
Okay, let's go on the record in that. Mr. Thompson, let's
Yes,
go on the record in People versus Brooks.
thank you.
That is, pardon me, file number 245344. That was set for hearing at 2:45. Both counsel are present here in the courtroom. Mr. Thompson, can you tell me, it looks like we did have a writ prepared and signed by the court for his appearance at 2:45. Have you been able to be in contact with him?
I haven't, Your Honor. He's in a different jail. So I don't have any information out for the court. I was gonna ask for some time to speak to him if he did appear, but I don't see him.
Have you had any contact with Roscommon County? It looks like that's where he's
We did. They requested that we get SCOTA to sign off on our writ, which is kind of strange. But we went ahead and did that and sent it to them. And it seems like everything was gonna be fine for today. I'm not sure what happened there.
Let's just pass that for now. If they do connect, we'll proceed. If not, then, I don't know, Ms. Cole, if you're staff, if you try to contact Russ,
Okay.
see if they can sign in.
I should have.
3 o'clock hearing. Mr. Adams.
I had enough contact with Mr. Adams to let him know when the hearing was. He's been a little hard to get a hold of. They did ask last week when the hearing was. And then is Ms. Smith at 3 o'clock? Oh, Mr. Brinker, I'm standby counsel on Mr. Brinker, so
No. We are a couple minutes ahead, so we'll take a short recess. I'll come back on the record in about 5 minutes.
and the marijuana.
state what the issue was, or?
All right, Mr. Adams, are you able to hear me okay? Or is that Brooks?
That's Brooks.
I'm sorry, Mr. Brooks.
Yes, yes, Your Honor.
All right, your attorney wants to be able to talk to you privately for a minute before we start your hearing, so I'm gonna open up a breakout room so that you and him can have a conversation.
Okay.
Miss Anderson, are you there?
Yes, I am.
Hi, can you just tell me which case you were signing in on?
Mr. Adams.
Mr. Adams, okay. We're not quite ready for that one yet, so I'm just gonna leave you in the virtual courtroom though.
Okay.
And ma'am, if you can come right up to the podium there, please. We're on the record in People versus Jennifer Palmer, file number 255413, effective counsel, please.
Sierra Coke on behalf of the people.
Jesse Williams representing Ms. Palmer is present to my right. Ms. Williams, we were intending to, the resolution of this case is if Ms. Palmer pleads guilty to MCL 750.520C subsection J, that's criminal sexual conduct in the second degree, a C-grid felony, with, sex offender registry requirements. People are going to dismiss all other counts. And our intention was to place the plea on the record today.
Okay, and that's the 15-year.
That's the 15-year.
Ms. Koch, is that a correct statement of the plea offer?
It is a correct statement of the plea
It's a
offer.
25-year. Oh, 15-year.
15-year penalty, 25-year registry.
Yeah.
And Mr. Williams, would you be prepared to question your client?
I could, Your Honor, I could do so.
Thank you. Ms. Palmer, have you had an adequate opportunity to speak with Mr. Williams about this plea agreement?
Yes, sir.
Okay, and is that how you wanted to proceed today?
Yes, sir.
Here's your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Lower your hand. Ms. Palmer, are you currently on any kind of probation or parole?
Yes, sir.
No, she's
Oh,
not. She's not
sorry.
bond, Your Honor.
Fine. Sorry, Your Honor.
That's okay. And you understand that by pleading guilty to the charge here of criminal sexual conduct second degree, the maximum possible penalty that you could face would be up to 15 years.
Yes, sir.
And you've discussed the registry requirements with your attorney. You understand what those are.
Yes, sir.
With that in mind, what is your plea to that charge today?
Thank you, Your Honor.
Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. Any appeal would have to be by leave. That means you would have appeals to hear your case. They said no, then that would be the end of any appeal. You understand?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay, Mr. Williams, if you would please confirm that.
Ms. Palmer, I've provided you the information in this case, correct? Police reports and other things.
Yes, sir.
And on or about the aforementioned date in those incident reports, were you here in this county?
Yes, sir.
And which county is this?
Crawford County.
And you were in Crawford County because you were where? Were you at work?
Yes.
That's in Crawford County.
Yes.
And what was the name of the institution or place you worked at?
Shimano Center.
And is that a correction facility?
Yes.
Are you employed there?
Yes, sir.
And what, during the course of your employment, you engaged in a relationship, correct?
Yes.
The person was 16 years or older, correct?
Yes.
But he was also incarcerated in that facility, correct?
Yes.
And by default, that's a crime, you understand, correct?
Yes.
And even though it was consensual, you engaged in intercourse, correct?
Yes.
And that intercourse would have involved some type of penetration, penile, vaginal, mouth, some type of sexual organ penetration, correct?
Yes.
I think that would be sufficient. Your Honor.
Ms. Coe, do you have any additional questions?
No, thank you.
Ms. Coe, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Williams,
None, Your Honor.
Ms. Coe, are the people satisfied that the court has complied with statute court ruling the taking of this plea?
Yes, Your Honor.
Yes, yeah.
Ms. Palmer, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support that you are guilty of this crime. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date, and time of that hearing. Before you leave today, you're going to meet with Mr. Haven from the probation department to set up a pre-sentence report. It's also important that you stay in touch with Mr. Williams prior to that hearing. Okay?
Yes, Your Honor.
Mr. Williams, anything further?
No, Your Honor, thank you.
Oh,
Senator, there was some issues with the dates. It looked like it was very gray whether the child was 15 or 16 when the sexual relationship started. I understand that her plea today, she indicated he was 16 during the penetrations. And we are waiting for a DNA test to determine whether the child she
You
was
know,
fathered.
I would, we've taken a plea, the court, the prosecutor agreed with the court rules. Whether or not there's additional DNA evidence related to this incident is not of consequence to the plea process. Court rule requires a factual basis. We established a factual basis. Prosecutor did not object to the factual basis. The court asked the prosecutor wanted to respond to that. The prosecutor did not. So I'd ask that we just move forward and straight this conversation.
well, I guess I don't understand. Why are we talking?
Your Honor, normally because there was a sexual assault of a minor, we would revoke her bond immediately under 770.90. The statute she pled to falls within that statute, which is 520C. It's specifically listed under there, but because she said the child was 16, that's one of the requirements. I was just putting it before the court, whether the court wanted to revoke her bond, given her plea. It is very likely we'll be looking at a lengthy prison sentence.
I don't think, given the nature of the charge and the testimony, that the court is required to revoke the bond at this time. There hasn't been any other grounds raised or why her bond would be revoked in terms of she's violated it in some way. So the court will continue the bond.
Thank you.
Because mom was on Zoom and you tried to be, I don't know all about it.
Yeah, Ms. Coke, if victims want to appear remotely for hearings, I have no objection to that, but I do need to know about it ahead of time. Because that random device names connect, in the waiting room. I have no idea who they are or what. So,
Thank you.
but I just have no objection to victims appearing that way. But I know about it ahead of time, so I can let them in.
We were trying to contact her, but we couldn't get through to her voicemail today, so we weren't sure if she was going to appear or not, but we did send her the instructions.
Okay, Mr. Thompson, you're ready under Mr. Brooks' case.
I am, thank you.
So we'll go on the record as People versus Brooks, file number 245344. Again, Mr. Brooks is appearing today by video. Common Jail, counsel's present here. Mr. Thompson, how did you want to proceed?
Thank you, Your Honor. We wanted to have the matter set for a hearing. I'll advise the court, Ms. Smith, just a second. I'll advise the court that Mr. Brooks advised that he has a July 3rd preliminary exam in Oscoda County. So we probably will be looking for after that. He'd be pleading not guilty at this time. He would qualify for assigned counsel and I would be appointed.
Okay. All right, so the court will enter not guilty plea on behalf of Mr. Brooks today. We'll sign that order for counsel once that's presented. And then we'll set this for hearing, set it out to, did you say August?
I said July 3rd is his prelim and we'd be looking for after that, please.
So we'll set this out to the court's full motion day in August for a hearing. And Mr. Brooks is being held, I'm assuming.
It is. He has a parole hold. I think bond is largely irrelevant at this point. So I'd ask the court to set a cash bond, so he's getting credit. But I don't think there's any real likelihood of meeting it.
Okay. to Ms. Coe, any position on bond?
No, Your Honor.
Court will set bond in the amount of $1,000 cash or surety. And then again, the court will proceed as indicated. Anything further on this file, Mr. Thompson?
Not for today's record, thank you.
No, Your Honor.
All right, thank you, Mr. Brooks. The court's going to disconnect at this time. People versus Richard Adams, case number 255414. Mr. Adams present.
I haven't seen him today. I did get a text from him, I want to say Friday. And I did advise him of the time and date for court. That was the last I had heard from him. I can check my messages to refresh that, but.
And we do have Ms. Anderson here on behalf of pretrial services. Ms. Anderson, was there anything you wanted to state regarding this file?
I just had it set for a show cause, for a, positive test and a missed test. I have not spoken to Mr. Adams, since June 5th when he missed the test. I did send a reminder text, last week, for this hearing and never heard back.
It looks like that last contact I had from him was on May 27th, Your Honor. So that's the most recent information I have.
Okay. Ms. Coe, people take any position?
We'd ask for a bench warrant.
On Mr. Adams' failure to appear and also his failure to communicate with pretrial services, which is a condition of its bond. The court will request a bench warrant and will proceed further with his file once he's arrested. Brought before the court. Thank you, Ms. Anderson.
Thank you. Have a good day.
People versus Brinker, file number 255411. This is set for 3 p.m. It's now 3:30. Mr. Thompson, I know you indicated your standby counsel.
I am standby counsel. I haven't had a lot of contact with Mr. Brinker. I spoke to him probably 2 weeks ago. And then I know there was email communication last week, but I don't have a direct report on his whereabouts today, Your Honor. I did check the lobby when the case was first called at 3 and I did not see him.
You know, he's emailed me numerous times. I mean, the court's very familiar with Mr. Brinker. We deal with him on a very regular basis here. He was trying to get his case adjourned for 60 days before trial for a variety of reasons. I indicated that I did not agree with that. We would just ask for a bench warrant for failure to appear. I think he contacted the court and asked to have his motion set on the same day as the hearing, so he was more than aware of the court hearing.
Judge, I did speak with him. He was aware of today's date. He filed his motion. I instructed him to get a court date for that motion, which then held your office got the court date for today's date so they could all be heard on the same date.
All right, so with that additional information, it's clear that Mr. Frank was aware of the hearing. I do see his filing here in the court file, which does reference the date, time of today's hearing. Absent some other reasonable explanation for his failure to appear, given the nature of the charges in this case, which involve third offense operating while intoxicated, the court does have concerns regarding public safety. The court notes this is also a fourth habitual or Brinker. So for all those reasons, the court will order that his bond be revoked and will request a bench warrant. Once Mr. Brinker's arrested, brought before the court will proceed further on this case. Are you ready on this case?
I believe so, yes.
People versus
If
Randy
you want to
Smith.
walk up, you stand right there.
This is file number 255419. The record should reflect Ms. Smith is present here in the courtroom today.
Sierra Coke on behalf of people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Randy Smith. Your Honor, in this case, we do have a plea offer to plea down to malicious destruction of property at the misdemeanor level. Sure.
an attempt count 2 RNO and an added count 4 MDOP 200 to 1,000 with full restitution and must show mental health treatment.
That is an accurate statement. Your Honor. Thank you.
What's the maximum penalty on this?
1 year for each of those, Your Honor.
Ms. Smith, have you had a chance to talk to Mr. Thompson about this plea agreement?
Yes.
Do you need any more time to do that before we proceed? And did you want to proceed with that plea agreement today?
Yes.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. Raise your hand. Ms. Smith, are you currently on any kind of probation or parole?
No.
You understand that by pleading guilty to the lesser destruction of property charge, the maximum penalty you could face would be up to 1 year in jail? I just needed to speak up a little.
Yes,
bit.
Your Honor.
Okay. We're recording it, so I have to
Oh,
make sure that
sorry.
your voice is picked up. And then the attempted resisting or obstructing, that also carries with it a maximum penalty of up to 1 year in jail. Do you understand that? With those two penalties in mind, what is your plea to each of those charges today?
Yes, sir. Oh, guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have to speak. Right to testify at a trial yourself if you wanted. You understand all those rights. You understand that you're giving up and waiving all of those rights by pleading guilty. Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Your own free choice to plead guilty. Are you pleading guilty because you are actually guilty? Just need you to say that again.
Oh, yes, Your Honor.
Yes, okay. So this happened on April 8th of 2025, is that correct?
Yes. Yes.
And were that, on that date, were you at the Ramada Inn here in Grant?
Yes.
And did you damage some property within that hotel? Did you do that on purpose?
No, Your
Okay, how did it happen?
Honor. I got scared, like, I had a lot of mental issues. I don't know if it's schizophrenia or what. I was diagnosed with schizophrenia and then I was told it wasn't, but I've got a lot of mental health problems that I'm trying to deal with and get worked out.
Okay, I guess when I say, did you do that intentionally?
No,
Was
it wasn't
an
intentionally.
accident?
I kind of had paranoid, like freaking out episode and that's how it happened.
You damaged the property during the course of that? Is that a yes?
Yes.
But it wasn't an accident?
Well, it wasn't an accident. It was in my mind to get out of where I was, just anxiety, emotions, everything.
Okay.
I can't explain it. It's in my head.
All right, I understand. And during the course of that, did somebody from the police department respond there?
Yes, sir.
Was that person wearing a police uniform?
Yes, sir.
Did you know that he was there performing his duties as a police officer?
Yes, sir. I got scared.
And did you do something to resist that officer when he was trying to do his investigation? What happened?
I think I was holding the door in the bathroom shut so that they couldn't get in.
And that happened at the Ramada as well.
Yeah.
Ms. Polk, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Thompson?
Yes, Your Honor. Thank you.
Ms. Polk, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Thompson?
No.
Ms. Polk, are the people satisfied that the court has complied with statute and court rule and taken?
Yes, Your Honor.
Yes, I'm satisfied.
Ms. Smith, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. set this matter for a sentencing hearing, be notified of the date and time of that hearing. It's important that you stay in touch with your attorney, Mr. Thompson, prior to that. You're also going to meet with Mr. Haven here before you leave court today for a pre-sentencing. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
You're gonna go out in the hallway, Mr. Hagan's gonna come out and meet you there.
Okay, Mr. Vernon and Mr. Cannon, if you can both unmute. Thank you. We'll go on the record in Heather Merchant Hart versus Secretary of State. This is file number 2511865. If I could have both counsel put your appearances on the record, please.
Adam Vernon on behalf of Ms. Hart, who's present seated to my right.
Good afternoon, Your Honor. David Cannon, Assistant Attorney General on behalf of the Secretary of State.
All right, thank you. I had this set for hearing. This is a petition by Ms. Hart to have her restricted license privileges restored based on a first implied consent suspension. I did receive a stipulated order from counsel. That was a bit unusual. I've not seen that before. I was uncomfortable signing that order without more of a record being made, which is why I requested that this be set for a hearing today. So Mr. Cannon, I guess I would start with you. Is there an agreement that Ms. Merchant Hart should have her restricted license restored?
Yes, of course, it's fully up to the court. There's no question in these cases that a stipulation still puts a great deal of responsibility on the court because the court is finally whom is awarding the driving privileges and therefore takes the risk of the problem if there is an incident and has to kind of assume that risk to the public. It isn't really me, other though I'm contributing on behalf of the Attorney General, but it's not my final signature. So there's no problem, I mean, with the court not readily accepting the stipulation. There are courts that don't in these cases. But also I noted as I looked at this today before we came to court that it was a little bit misleading. Everything I say in there is correct. I drafted this one. But I gave you a wrong statutory cite. The outcome would be the same, but I would just like to maybe elaborate on the situation. The person has a normal implied consent suspension, and that's what's before Your Honor, and that's all that's before Your Honor, because of course anything on the high BAC conviction was perhaps before you or perhaps before a different judge, I don't know. But anyway, it's not here before us today. But she did have that high BAC conviction, so she gets a suspension for that for 1 year. She's eligible for restricted driving privileges on that conviction, and that cite should have been MCL 257.319, paragraph 8, little g. Which is not the cite I put in there. That second cite is incorrect, and I'm going to cross that out on my copy right now. So if you look at that, Your Honor, it would say that she's entitled to these restricted privileges after 45 days of being suspended, which I'm sure probably has passed by now for her. And then it provides further restrictions at paragraph 16 of the same statutory cite, that being 257.319, paragraph 16. Those limitations on her driving privileges are almost all the same as the implied consent limitations a court has in providing restricted privileges. Of course, your jurisdiction lies under MCL 257.323, which is your authority to review Secretary of State final decisions and change them, basically. And in implied consent cases with, when restricted driving privileges are granted, there's a further limit on that jurisdiction at 257.323C. Well, those limitations are pretty much the same as the limitations on the high BAC conviction. So the end result is what I stated in my little paragraph there. I just that I gave you the wrong site. And what they are to and from work, course of employment, the medical, emergency medical, education, counseling, AA, and community service, court functions for the underlying conviction and community service, if any, probation requirements, if any. And so they pretty much parallel. So I thought that with the interlock requirement being mandated for the entire period of the implied consent under the other statute, the high BAC statute, I felt that that was probably adequate to minimize the risk to the public, that I was comfortable putting a stipulation. And that doesn't mean the court has to accept that, but that's what I offered. That's what I do in other cases that I handle throughout the state. And now that we have got to the correct site, I've led the court to the correct site, I would just like to add that your authority under the implied consent statute could put other restrictions on if you wanted to. I mean, I have done many of these where persons are, it's not just the generic language of to and course of employment. It would be to from course of employment at food fair in Grayling, or it could be to from course of employment Monday through Friday, 6 a.m. to 6 p.m. and Saturday 9 to 5 or something, or whatever the court wants if you feel other restrictions are in order. But just to, so I fully advise the court, she is going to be under the interlock. And to that extent, it's probably among one of our safer risk implied consent restricted licenses if Your Honor feels comfortable with it.
All right, thank you very much. I appreciate that. Mr. Vernon.
So I would say all of those things are true. I did want to provide the court with a little bit of background with regards to our motion and our brief on this matter. We did have an implied consent hearing. The officers appeared and testified. They failed to identify the offense that Ms. Hart was arrested for, but we filed this appeal, ordered the transcript, and it was then after we filed the appeal, we were informed that the transcript was not going to be able to be made, and that somehow the audio and video had been corrupted or unable to be reproduced. And after that, I had a conversation with Mr. Cannon about resolving this in another way. I again believe that our appeal was meritorious, and I think it would be if we had a transcript, but with the understanding that the only further recourse would be to rehab the hearing, at which point it's very likely the officers involved would correct any legal mistakes that they made. Doesn't necessarily benefit my client to do that, and Mr. Cannon and I agree that that seemed like a waste of time on everybody's part, and that this was a good way to resolve it, with the understanding that the restrictions set forth under the conviction for the BAC, the high BAC that she pled to, would mimic and almost exactly follow the implied consent. So we thought this was an appropriate way to resolve it. So we would ask the court to allow that to take place.
Mr. Vernon, I was the judge that presided over the criminal case, but I would like to or ask you to make a record of Ms. Merchant Hart's current status in terms of her probation and supervision at this time, and the length of that.
So she is on probation. She is meeting with Mr. McFalda. She is still in good standing. There have been no allegations of violation. She has a report date. Her next report date is on July 16th with Mr. McFalda. and she is scheduled to report in person the third Wednesday of every other month.
And the length of her probation?
Was 1 year.
Okay,
She gets all of her rights.
okay. All right, so, again, I'm already familiar with Ms. Merchant Hart and the circumstances underlying, the arrest in this case, having presided over her criminal case. So I have much more information than I typically might regarding the individual's background and circumstances on a petition like this. I'm aware of the conditions of her probation. I'm not aware of any violations of her probation, any positive drug or alcohol tests during her time on probation. I'm aware that she has, paid all her fines and costs, which in and of itself doesn't mean anything other than that she is complying really in every way with her probation, which gives the court some confidence that she's going to continue to comply with her probation and would comply with any restrictions on her driver's license. The court also, in this case, as both counsel have indicated, there are already restrictions in place which would in essence mimic the restrictions which the court would allow in this case. So for all those reasons, the court finds it would be appropriate, given the degree of oversight, given the nature of the restrictions, given that there would be an interlock device involved, which again would, in my view, provide a measure of protection for public safety, given the continued oversight on probation and the likelihood that if she does test positive, she'll face additional criminal sanctions, and her full compliance thus far. For all those reasons, I find that it would be appropriate to grant the petition. And again, as Mr. Cannon's indicated, it's within the discretion of the court, regardless of whether the parties have agreed to it. But the fact that there is not an objection from the state, I think is also a factor that the court would weigh in favor of granting it. So for those reasons, the court will grant the petition. And Mr. Vernon, if you would submit an order. I did not see one in the file for the court to sign. So if you could submit that to the court.
So just to be clear, because we had discussed a couple of different things, the court is approving the interlock device and we don't have to make further petition at this point?
Correct.
Okay, I will draft that order then, thank you.
And then the restrictions, although I appreciate Mr. Cannon's suggestion, and certainly the court has in other cases, more specifically tailored the restrictions. I find that the standard restrictions would be appropriate in this case. So I want to make that record as well. And the court will sign that order once it's been presented. Mr. Cannon, anything further for the record today?
No, Your Honor, I appreciate it. I appreciate the opportunity to appear on Zoom, even though I was wanting to get into Crawford Circuit Court finally. I have a place here on Houghton Lake and I teach at Kirtland at the police academy. So I'm up here a lot, but I really appreciate this because I do a lot of distant court hearings, and this is obviously a very expeditious way to accomplish this.
Certainly, absolutely. Mr. Vernon, anything further from your side?
I just wanted to clarify with Mr. Cannon, the statute that he identified where the restrictions were set forth.
The restrictions set forth for the implied consent are 257.323C. So that's what the court is ordering here, those restrictions. That's also in the scale form, the standard form, if you use that. And then the restrictions that her high BAC, which are almost the same, but maybe just a tad bit different, but you don't have to really cite these, but she should know that it's a combination of these two restrictions, whatever is the most restrictive. So they're found at 257.319, paragraph 16.
Thank you. Nothing further, Your Honor.
Thank you.
Okay, thank you. All parties on this file are free to disconnect at this time.
Thank you, Your Honor.
All right, folks, thank you for being here. My name is Judge George Mertz. You're here based on failure to appear for jury duty or failure to submit a jury questionnaire. And so I've just got some things I need to go through with you, and I'll see if any of you have any questions about jury service. But first of all, I do want to impress upon you how important jury service is. Jury service is an important part of a free society. It's part of the government's system of checks and balances. So if we're talking about a criminal case where somebody's charged with a crime, you know, the prosecuting attorney and law enforcement as the executive branch of government can think that you or one of your citizens has committed a crime. But that's not enough under our system of government for them to accuse you. In order for somebody to be guilty of a crime, they have to be able to convince 12 of that person's fellow citizens that they're actually guilty of a crime, and they have to do that beyond a reasonable doubt. It's also, the jury is an important check on the judicial branch of government as well, because in some systems of government, the judge is the one who decides guilt or innocence, and the judge can take away somebody's freedom. In the United States, under our system, I'm not the one who makes that decision. The jury, you as citizens, are the ones that have the power to take away somebody's freedom by finding them guilty of a crime. And so for all the knocks that our system gets, it's the best in the world, and it's that way because there are those checks on the executive branch and the judicial branch, and it really is up to you, the citizens, to make those decisions. And that's why having people appear for jury duty and fulfill that function is incredibly important to our system. It's a protection for you too, as citizens. In civil cases where we're not dealing with a crime, you know, there's disputes between people. People sign a contract and one side doesn't follow through on it, or somebody damages somebody else's property, or there's some kind of negligence, or there's a dispute over a property line or something like that. The jury decides those kind of questions too. And in the old days, you know, people had duels and fought it out. Now we use juries as a peaceful way to decide those disputes between neighbors and fellow citizens. And so the jury is an important part of the court for those reasons too. And in appearing for jury duty in a civil case, you're helping your fellow citizens resolve disputes between themselves. And if you ever had a dispute, you would want a jury to be able to come in and help you resolve that dispute. So it's an incredibly important part of the court. It's an important part of our community. And it's so important that when folks don't appear, number one, we order you to come in so that we can find out why you didn't appear. And if you don't appear or respond to the call of the court, it's so important that the court can impose sanctions like fines or even imprisonment. That's not something that I would ever want to do for people who didn't show up for jury duty. That would be an absolute last resort. But that's how important jury duty is, that if you don't comply with it, that you could face penalties. So it is a last resort. It's not something that I want to do. I'm not going to impose fines or any penalty on anybody here today. I think having to come in and listen to me give this little speech is probably enough of a punishment for you. But I hope it does impress upon you the importance of jury duty and why it's important. And I'm confident that in the future that you will respond. If you have reasons why you can't appear for jury duty, you can let us know ahead of time. If they're reasonable, we can excuse you from that jury duty. Sometimes we can even excuse you permanently if you have some kind of long-standing health issue or something like that. But we deal with those on a case-by-case basis. So that's my spiel. Do any of you have any questions about jury duty or why you're here today? Michelle, is there anything else that I can cover with these folks?
No.
All right, thank you for being here, and you're all free to go.
We just have the ones that did not appear.
My dog ate my homework. I don't even get to say.
Yeah, that happens.
So we have 2 on the ones, and we have, I just sent 2 out to do that, so we've got 38 for the questionnaires that are still
out.
Yep.
The 2 that did not appear today, yes, I would like those to be personally served. And then there's 38 for the questionnaires.
It's like a third of last year's.
Hi there. You have a question?
I have a note from my doctor